Hello, this is John Pankauski of Pankauski Hauser in downtown West Palm Beach, Florida, and this is the Florida Bar approved continuing legal education course, When Worlds Collide, Florida Family Law, Divorce, and Probate, what you need to know. By way of introduction, I'm John Pankauski. I'm a partner with Pankauski Hauser in West Palm Beach, Florida. Our firm limits its practice to trials, disputes, and appeals involving wills, trusts, estates, and related areas such as guardianship, homestead litigation, life insurance contracts, and annuities. Our firm does not prepare estate plans. We don't draft wills and trusts, but we do litigate those matters. And today we're going to be talking about a subject for which you'll receive 1 credit hour from the Florida Bar if you're a licensed Florida attorney on what others have called dollars, death, and divorce. We're going to talk about the collision or the overlap between family law in Florida and probate law. And you can see our building at 415 South Olive Avenue in West Palm Beach in front of you. That's where we're broadcasting from. Actually, we're doing this live webinar that's free of charge right now. And if anybody needs additional CLE credits or ethics credits, you can go to our website, phflorida.com, P like Pankauski, H like Hauser, Florida.com. And there's a button up top that you can click on called videos, and you can scroll down and find webinars, CLEs, and videos. And you'll be able to attend online. You'll be able to view other webinars that we offer free of charge. And you'll get Florida Bar approved continuing legal education credits. Look for sometime after October of 2017, continuing legal education courses for technology. As we know, starting January 1 of 2017 for reporting cycles on and after that date, there's a 3-hour per cycle requirement of technology continuing legal education. And our firm, Pankauski Hauser, is going to offer some technology credit for Florida licensed attorneys. If you need ethics credits, we have a number of ethics credits that are available online for free. Go to phflorida.com, look for our videos and webinars, and you'll see CLEs, and it'll indicate how many credit hours are available and whether you'll be able to get credit hours for ethics as well. Today's discussion topics, we're going to talk broadly about the overlap of family law or divorce law and Florida probate law by way of introduction. And then we're going to talk about a divorce proceeding when death is imminent. We think one of the spouses who's divorcing or is subject to a divorce proceeding is about to die or is going to die, compared to when death is not expected. Then we're going to discuss the guaranteed inheritance rights of a Florida surviving spouse, one of those legal actors upon whom Florida law bestows very, very valuable property rights, many of which are not well understood, and many of which have some very short windows to exercise those rights. We're going to speak specifically about ex-spouses or former spouses as creditors. This is a recurring theme that Rob and I see in our law firm in West Palm Beach all the time, right? We get lots of calls from somebody who was divorced and their former spouse is now deceased. And there's issues of marital settlement agreements or judgments that are outstanding and unsatisfied, and rights of former spouses, and also of minor children as well. And many times we see that in the way of property division or payments that are not made, or life insurance. A lot of life insurance disputes between spouses. We're going to talk about premarital and postnuptial agreements, marital settlement agreements, final judgments, and some recurring problems that we see over the years. So by way of introduction, we're probate lawyers. We're not divorce lawyers, and we're not family law lawyers. But I can't tell you how many calls we get from family law attorneys because there's a trusted issue, or there's a minor and there may be a guardianship issue, or one of the parties to a divorce proceeding is getting along in years and maybe suffering from dementia, and there's an incapacity issue. So you have guardianship law. Many, many times you're seeing guardianship proceedings late in life for adults, for senior citizens who are losing capacity, losing competency. And there's a guardianship proceeding, and the issue of a divorce comes up all the time. And there's a big black hole of a legal issue about whether you can get divorced when there's a guardianship proceeding that's been initiated. And some lawyers say you can't, you've got to wait 3 years, and others say, sure, you can, there's a way to get around it. And I think we're absolutely going to need a little bit more guidance from the legislature on that. But we get lots of calls from family law attorneys because if there's a guardianship that's involved, sometimes a divorce is discussed, or there might be a minor that's involved, or there's a trust that's involved, and sometimes there's multiple trusts, right? Or there's a spouse who's just become deceased. You're in the middle of a divorce. One of the spouses passes away, and you need to go to probate court, you think. And in that situation, where one spouse to a divorce proceeding has passed away, now you're kind of, litigating in two courts, right? Because there may or may not be business to attend to in the family court where the divorce proceeding or the dissolution proceeding is occurring. And we know we definitely have to go to probate court, right? When we have a dead body in dollars, we know we've got to do something in probate court. And if we don't do something in probate court, bad legal things can happen. So we're going to talk about the overlap today, or what I call when worlds collide. And on the screen in front of you see an American Bar Association article I wrote a few years ago in the Probate and Property magazine, When Worlds Collide, that discusses this particular topic. And for any divorce lawyers who are attending or listening, or any family law lawyers and probate lawyers as well, if you'd like a copy of either of my two books, just email us or call us, and it'd be a pleasure to mail to you free of charge Pankauski's Probate Litigation Guide, the top 10 probate mistakes that we see consistently from estate plans. And I also have a second book, Pankauski's Trustees Guide, which goes into great detail about what makes a good family trustee and where they get into trouble. And it'd be a pleasure to provide those free of charge to any colleagues who would like a copy. You can call 561-514-0900, extension 101, or you can just email amanda@phflorida.com. So as we start talking about death dollars and divorce, this is a statistic that I consistently talk about, $56 trillion. That's the amount of money that the Boston College Center of Wealth and Philanthropy has estimated is being transferred and will be transferred over the next couple of decades from the World War II generation to more remote descendants, right? Whether it's the boomers, Gen Y, Gen X, or the millennials, a lot of money that's changing hands. And so you've seen probate litigation almost become a growth industry within the legal community, right? Within the legal profession. 56 trillion reasons why people are questioning their trustees or executors or personal representatives, or questioning estate plans and hiring lawyers. And so if you're a divorce or family law attorney in Florida, and you're out there and you're saying, well, I need some assistance because somebody to a divorce proceeding just passed away, there's a lot of great probate lawyers out there, particularly in Palm Beach County. Only a handful of us litigate, right? Only a handful of us understand Chapter 90 and important rules of appellate procedure, how to examine a witness, cross-examine a witness, get documents into evidence. So just be mindful of that. Probate lawyers are wonderful for opening up an estate and getting things moving and filing a lot of the paperwork that's required. If you're dealing with an adversary proceeding, if you're dealing with a creditor, you're going to have evidentiary hearings and trials, and particularly if there are independent actions filed by a creditor, such as a former spouse. And be mindful that you not only need probate skills, but you need litigation skills as well, as everyone's grappling over that money and fighting for that money. Okay, so divorce, when death is imminent. Let's talk about you're in the middle of a divorce proceeding, and you're convinced that one spouse is going to pass away. Maybe they have a terminal condition. Maybe they've been told that their life expectancy is now very, very short. And so, family law lawyers consider bifurcating, right? And they'll file a motion, and they may or may not provide evidence of this at a hearing. And they'll go to the family court judge and they'll say, hey, this spouse is about to die. Why don't you go ahead and bifurcate the proceedings, grant the dissolution of marriage. These people obviously want to be divorced. Grant the dissolution and reserve on property distribution. And we can deal with that later. And so when you bifurcate, if somebody is divorced, if there's a dissolution proceeding and you get a judgment of dissolution or a divorce proceeding, that spouse is no longer a spouse to the other. And so now that creates a host of issues. And the reason for that is if you're no longer a spouse, you no longer get all the benefits of inheritance which a spouse gets. Because in Florida, very unique state, very abundant, very valuable property rights for a spouse if you survive your other spouse's death, right? And we're going to go into those in great detail. Very, very valuable property rights, even if there's no will, even if a will leaves all your property to somebody else. Yes, spouses have very valuable property rights, even in the face of no will, and even if the will leaves property to somebody else. Just be mindful, the statutes of limitations and the time frames in probate proceedings are exceedingly short. They're usually expressed in days or months. Unlike other statutes of limitations, which are considerably longer. So if you're in the middle of a dissolution proceeding or a divorce proceeding, and remember, a dissolution proceeding, a divorce, you go to divorce court, right? We have divisions in Florida within our civil circuits, and the family court handles divorces. The probate division handles estates and trusts. So a judgment of dissolution will end the marriage and end the inheritance rights. And then you've got to figure out, well, what do I do with that spouse now who's divorced, is no longer a spouse? What am I going to do? Well, that spouse is most probably a creditor of the deceased spouse's estate. So that surviving former spouse who's in the middle of the divorce proceeding is now a creditor and is owed money from the deceased spouse's estate. And so you're going to have to open up a probate and you're going to have to exercise your rights, right? So in this bifurcation proceeding, if you know that death is imminent, the family law court can retain jurisdiction to determine property rights at a later time. And so if you're a probate lawyer out there listening, because most of our CLEs, most of our webinars that Pankauski Hauser produces free of charge online are geared toward estate planning lawyers, probate lawyers, and trust and guardianship attorneys, and elder law lawyers. We try to provide free of charge, Florida bar approved continuing legal education credit for people who have a probate practice. All right, let's talk about the situation where there's a divorce, there's a present dissolution proceeding, but death is not expected. Slightly different circumstances. Generally speaking, there's all these special rules for when a party dies. When a party to a lawsuit dies, generally you hear trial lawyers say that the proceeding abates, right? And there's a statute on it that talks about that. Procedurally, what you need to know is that you have to do stuff if a party dies. You have to file a suggestion of death with the court, and that kind of is silly to some people because usually there's no suggestion or doubt that someone's dead. They're gone. But you have to file a suggestion of death. And then you need to determine whether you can substitute anyone in the deceased party's place. And in the case of a divorce proceeding where one spouse dies, you should not only file a suggestion of death, but you should also file a motion to substitute the personal representative in place of the deceased former spouse, or I should say the deceased spouse. You want to get a named personal representative in there because there's probably going to be some stuff that's going to happen in the divorce proceeding. There's going to be some stuff that's yet to be done, and the estate needs to be represented, right? Because the estate may or may not have to pay the surviving spouse or the surviving former spouse, right? So you need to be mindful of that. Now, to get a personal representative appointed, you've got to open up a probate, right? You've got to go to the probate court, file a petition for administration, pay the $400 filing fee, serve the interested persons, get the death certificate and file it. That's what you've got to do. And then you have to go another step, and you have to have somebody appointed as personal representative, someone to serve as the executor of the estate. Now, be careful if you're a divorce lawyer or a family law lawyer of some things not to do. Don't forget to file the suggestion of death. Don't forget to file a motion to substitute the personal representative in. Don't forget to open a probate if no one's opening a probate, right? That many times, we get calls at our law firm that say, so-and-so died, I'm owed money, or I'm owed an inheritance, but no one's opening up a probate, right? Happens all the time. And so regrettably, what you have to do is, if no one's opening a probate and you have rights or money that you're owed, or you have an inheritance, usually you have to go get it. You have to go down and open up a probate. Now, the good thing about that is there are statutes which do permit you to recover some or all of your attorney's fees for doing that work. So one final thing you don't want to do in a divorce proceeding is just name the heirs as a substituted party for the deceased spouse, or name the estate as a substituted party for the deceased spouse. The estate is not a party, and there's a district court of appeal opinion that specifically says that you can't name the estate of somebody. You have to name a personal representative, which means you have to open up a probate, file a petition for administration, serve the right people, and then have the judge actually issue an order on your petition for administration and letters of appointment or letters of administration, which grant authority to a named personal representative to administer the estate. Likewise, you can't just name heirs or the family of a deceased spouse. You've got to do it, and you've got to do it right, or you end up running the risk that you end up losing based on procedural or so-called technical basis. So we're talking about divorce proceedings, and number 4 in our outline, the Florida surviving spouse inheritance right, when death was not expected. One of the reasons we're talking about this is because Florida gives such valuable property rights to spouses. Really, really valuable. And duration of marriage is never a factor in inheritance rights in Florida. And so I often give this example in a way to demonstrate how valuable the property rights are without any basis of duration of marriage. So whether you are married for 50 years in a blissful, loving relationship, the law makes no distinction between that and somebody who is married for 2 seconds, right? And so if you're in Las Vegas and it's 3 a.m. and you decide to get married and your spouse doesn't sign a prenup, and you get married by Elvis at a church in a chapel on the Strip, and walking across the Strip, you go to a casino to celebrate, and you're struck by a car and killed, even though you were married for only a couple of minutes, that doesn't matter. The surviving spouse has a lot of inheritance rights, unless they waive those rights according to law or sign some type of prenuptial agreement. Duration of marriage, typically in inheritance rights, never a factor. A little bit different for family law, right? When we look at alimony and property distribution, duration of marriage is a factor. So what are some of the rights that a spouse has? Well, you're entitled to a family allowance, right? It shall not exceed $18,000. That's statutory. You have certain rights to personal property and an automobile, right? There's certain exempt property, that is by statute that a surviving spouse has an opportunity to get their hands on, right? And you can see the statute that's in front of you. And so many times you do deal with hearings on filing a petition for a family allowance, filing a petition for exempt property, and particularly for minors as well. So the red flags is if you have a surviving spouse and if you have a minor child, you most probably should be filing a petition for family allowance. The maximum you can get is $18,000. Just be mindful and try to be smart with your client's legal dollars about how much time you have to spend getting that money. Homestead, very, very valuable issue, right? Homestead is your one true abode. We know that there's three aspects of homestead. One is how much can your property taxes be raised every year. We're not discussing that. With creditor protection, that's the second big issue for homestead. We're not discussing that. The third issue is descent and distribution, right? You're actually limited on how you can give away your homestead if you're survived by if you have a spouse or minor children, and how homestead descends or goes to heirs or goes to people, or how it's inherited if you're survived by a spouse or minor child. So there's all these rules for conveyances during life and leaving your homestead upon death. And spouses have very, very, very valuable property rights, including to homestead. In fact, the Florida law recently changed, permitting spouses who had a homestead interest to get more cash sooner. What do I mean by that? In the old days, a surviving spouse who had an interest in homestead got a life estate, the right to live in it for their life with the obligation to pay expenses. But now, if a certain election is made within 6 months of administration, the surviving spouse can say, I don't want that life estate. What I do want is half. Let's sell the thing, give me half, I'm on my way. And in which case, you wouldn't be retaining the right to live in that homestead. You'd be taking half the cash. A very, very valuable property right. I mean, at Pankauski Hauser, we see on a recurring basis many, many people, including those with spouses who die without a will, with real property, their homestead in their own individual name. And then the issue becomes, well, what happens to that homestead? Well, it might go half to spouse and half to kids. It might go all to spouse. And then you've got to make sure that you get good title to it. And you need to determine whether someone's going to live in it, like the spouse, or whether they want it sold, and whether they've filed their petition to get their share of the one half in a timely manner. IRAs and retirement accounts are absolutely something that's litigated a lot about. Spouses have very special rights to retirement accounts, so-called qualified plans and non-qualified plans. And many times you see forms and contracts for changing the IRA beneficiary designation on an IRA requiring spousal consent. So anytime you're dealing with an IRA, right, or a retirement account, you want to read the beneficiary designation and whether any changes have occurred, as well as the contract. Read the IRA contract, read the retirement account contract. An IRA generally is considered exempt from probate or a will substitute because it, like most forms of beneficiary designations, it passes automatically by operation of law to the named beneficiary. Very similar to life insurance proceeds with a beneficiary and annuity contracts with the beneficiary that we seem to be litigating a lot about these days. The elective share is something that lots of lawyers know about. It's a very, very valuable property interest for spouses. It's not always well understood. When we talk about the elective share, it's all about marriage. If you're validly married to someone, you have a right to take an elective share. That is a minimum or guaranteed amount of your spouse's estate that you get when that spouse dies, right? So with the elective share, right, we need to be careful because you can waive those rights. You can waive those rights in a couple of ways. You can waive it in a writing, and waiving inheritance rights requires a document to be signed according to the formalities of a will. You need a couple of witnesses, and it needs to be signed, okay? And then the elective share can also be waived by signing a valid prenuptial agreement or postnuptial agreement, right? And so if your spouse passes away and leaves everything to his brother or her mother, you as a spouse can say, whoa, I have rights, and one of those rights, not necessarily the only right, one of those rights that surviving spouse has is to claim the elective share. Now, there's three parts to an elective share that you really should be concerned with. One is entitlement, two is calculation, and three is satisfaction. One is entitlement. Are you entitled to get an elective share? Did you waive those rights? Did you in any way give them up? If there's a prenup or a postnup, who has the original? How do we know it's still valid? Prenups and postnups are considered contracts. They're interpreted and enforced or not enforced according to principles of contract law. We do this virtually every week in probate court, right? Courts are looking at prenups and postnups. I was just in a guardianship trial, and the issue of a postnup came up and was brought in as an exhibit. They always come up. So whether one is entitled to an elective share depends on whether they're a validly married spouse and whether or not they've waived those rights. And we know from case law, we know from published opinions by district courts of appeal that broad language in a prenup such as I waive all my rights may be sufficient to waive all inheritance rights, including an elective share. You don't necessarily need magic words for a waiver to occur. Same-sex couples, gay marriages, this opens up an entirely new legal avenue for you, even if you've been validly married in another state, right? We know that before a recent federal court case and certainly before the U.S. Supreme Court case, Florida didn't recognize same-sex marriages. We're required to now. And so same-sex couples have inheritance rights. And so if your partner in your gay marriage dies and leaves all their property by an old will to their mom or dad or a prior partner, you as a surviving spouse still have inheritance rights unless you waive those rights, okay? Entitlement, very important factor to Florida's elective share for spouses. Calculation. Everybody seems to know that the elective share is 30%. What everyone is not always sure of is 30% of what, right? And a bunch of years ago, Florida changed the elective share statute entirely. You now, as a surviving spouse, get 30% of the elective estate. The elective estate is a basket, and our statutes tell us what assets to put in that basket, what assets don't go in that basket, and then what we do is we calculate it by multiplying 30% by the elective estate. Couple of really important points on the calculation of the elective share. One is there's a whole procedure for the personal representative to do it. But if the personal representative isn't doing it, you as the surviving spouse can do it, right? You can go ahead and do some calculations, and there's a whole procedure for that in the probate code that you can read about. The second thing is be mindful of how you calculate or value assets for the purposes of the elective estate and calculating the elective share. Gifts within 1 year of death are included. That's huge, should not be overlooked. If you're conducting any discovery of the decedent, you want to determine what gifts, what transfers, what gratuitous transfers were made within 1 year of death. And you can do this through interrogatories, depositions. You can also do it by issuing a subpoena and getting tax returns or drafts of tax returns that demonstrate what gifts were made, because gifts are supposed to be made or recorded on the U.S. Form 709, the gift tax return. Finally, big issues about satisfaction. Where is your 30% going to come from? There's a whole set of procedures and rules in our probate code for the satisfaction of your elective share. We take 30%, we multiply it by the elective estate, we get a dollar figure. Then we determine where that dollar figure is going to be satisfied from. If you've received certain assets from your spouse because of a joint tenancy or a beneficiary designation or a survivorship provision, there's going to be an offset. So there's an important calculation that needs to be considered. The intestate estate, be mindful, if somebody dies without a will, the surviving spouse gets at least 50%, and it may be 100% depending on whether there are children of the marriage and whether the children depending on whether the decedent had children and heirs and whether or not they were products of that current marriage. Okay, and you see the probate code statute in front of you, 732-102, that talks about the spouse's share of the intestate estate, and the very next statute talks about the share of others' interest in an intestate estate. As we're over the halfway mark now, let's talk about a former spouse as creditor. A former spouse under a marital settlement agreement or under a judgment of dissolution or an order on property distribution from a divorce is now a creditor of the spouse that just passed away. So we need to be mindful that you're probably going to have to open up a probate. Why? Because you're going to need to file a statement of claim. For any creditor of a deceased person, whether you're a former spouse who's owed money under a marital settlement agreement that says, for example, I'll transfer to you X millions of dollars, and the dead person didn't live long enough to transfer all that money, or the marital settlement agreement says I'll transfer X dollars to you every single year, and here's what happens if I die. That marital settlement agreement is a contract, and to exercise your rights to a contract, you need to open up a probate. Why? Because that former spouse now, that surviving former spouse, is now a creditor of the estate. And you've got to file a statement of claim. So not only do you have to open up a probate, file a petition for administration, get a personal representative appointed to administer the estate, you've got to file a statement of claim. It's not enough that you open up the estate, file a statement of claim, and any interested person can object to that statement of claim. And if they object to that statement of claim, you've got to file an independent action within 30 days, which means you go over to the civil division and you file your civil lawsuit for breach of contract or whatever cause of action you're bringing. And now you've got a probate proceeding and you've got a civil action. And the civil action may or may not be transferred to the probate proceeding, depending on what the cause of action is and depending on whether those causes of action are seeking a jury trial or not. The law recently changed as far as getting extensions of time to file a statement of claim and objecting to statements of claim. Talk to a probate litigation attorney about that. You want to get your statement of claim at ASAP. In some instances, you may only have 30 days. In some instances, you may have 3 months. Conceivably, you may have longer. I can't tell you how many times we're in court litigating about statements of claim. Understand that under no circumstances can you file a statement of claim to a deceased person's estate after 2 years of death, 2 years after death. Short statutes of limitations. Independent actions, you got to ask yourself where you want that to be tried. So in our example, if you are a beneficiary of a marital settlement agreement and you're owed some money from your spouse who's now a former spouse who's now deceased, does it make sense to have that matter heard in the probate court? You may have no choice if there's an administrative ruling that talks about transferring of sister cases. In Palm Beach County, you have to file a notice of a companion case, and the higher numbered case typically gets transferred to the lower number. But there's exceptions to all of this, right? And if you want a jury trial, such as if there's a fraud count or something, or a tort, you may be able to stay in the civil division, or it might get transferred to the probate division, and the probate court judge is going to do all the work except try the case, and then it'll get transferred back to the civil division where they'll impanel a jury. Notice is really important. Please be careful. If you're a surviving spouse or you're a lawyer and you're getting a notice to creditors served upon you or your client who's a former spouse, you have a very, very short window of opportunity to exercise your rights. Don't delay. One of the issues that always comes up now, everybody in their estate plan has a pour-over will, a revocable trust, also called a living trust, and whether you need to involve the decedent's trustee of their revocable trust. And just be mindful that, look, a revocable trust in Florida is absolutely responsible for all the debts of the creator. So you can't put all your money in a revocable trust and die and thwart your creditors, okay? When somebody passes away, there's actually a couple of notices that need to go out, sometimes confused. One notice of trust is something you file with the clerk of the county for where the decedent resided at the time of his passing. And that notice of trust basically says the decedent died having created and been a beneficiary of a revocable trust that's responsible for the payment of all the decedent's debts, obligations, and expenses of administration. So if there aren't enough probate assets to pay claims, pay creditors, pay taxes, pay your last expenses, don't worry. The trust, if it has assets, will be responsible for that. The second notice of trust is one that a trustee sends out to beneficiaries that says, hey, I'm a trustee. The creator just died. Here's my address. Here's who I am. You're entitled to a bunch of information and accountings. Call me if you need me. Be mindful of that if you have minor children or if you have children who were minors who now are adults. Because if they're beneficiaries under a marital settlement agreement, or if they're a third-party beneficiary under a judgment on property distribution, they may have rights separate from the divorced spouse, the surviving former spouse, and they need to exercise those rights. We see that a lot in the context of insurance, where a marital settlement agreement is executed and one spouse agrees that they'll keep $1 million of life insurance on their life for the benefit of their kids, and then the decedent passes and there's no life insurance, or the beneficiary was changed. There's ways for divorce lawyers and family law lawyers to address that when you're preparing the marital settlement agreement. The easiest way is to say that, the person who's going to benefit from that insurance is going to be the owner and is going to be the beneficiary. And if you're the owner or you're going to get the benefit of that life insurance policy, such as if you're a former spouse and that insurance is for your kids, is you want to get copies of notices from the insurance company so you know if the premiums are being paid, and you want the opportunity to pay those premiums if the person who's responsible for paying those doesn't. Also, you can draft very clearly into a marital settlement agreement who's the owner, who's the beneficiary, who's responsible for premium payments, and what to do if one isn't made. Right? Because in the insurance context, you have different legal actors. You have the applicant, you have the insured life, you have the beneficiary, and you have the owner. Okay, prenuptial and postnuptial agreements. As I said earlier, these are litigated in probate court all the time, right? And so we get into the formalities for execution. And we know that under Florida law, that a prenup is a little bit different than a postnup. And you shouldn't always assume that the agreement is valid. It may not be, right? Divorce lawyers would tell you, or family law lawyers would tell you, that they've filed the petitions to have a prenup set aside based on fraud or duress, or, you know, improper formalities, you know, such as the lack of full disclosure for a postnup or something like that, or a lack of an asset list or an inventory list. But you know, from a Chapter 90 or an evidentiary standpoint, who's got the original? And if you don't have the original, can somebody explain why you don't have the original or where the original is? So be mindful of that. Probate lawyers, a lot of probate lawyers who don't litigate come into probate court and they just start asking questions of documents that they throw in front of witnesses that often are not objected to, right? And many times they don't know how to lay a predicate or a foundation to get a document into evidence, and they struggle with getting a document into evidence because they're not capable of getting the correct witness up there on the stand who can authenticate the document, right? Or speak about personal knowledge of the document. And many times they don't have the originals, right? So be mindful of that. And we know in Florida that full financial disclosure is generally not necessary for premarital agreements, although they may be, or indeed they are for postmarital agreements. And that's because in Florida, Florida law places a greater duty on spouses because there's a confidential and fiduciary relationship between them, requiring fair dealing and full disclosure. Not so prior to marriage. Waiver of spousal rights was something that we discussed earlier, right? You can waive spousal rights. Check out that probate code statute 732.702, right? For how to waive spousal rights for inheritance and estate and probate purposes. And then you do have a new statute, a relatively new statute that expanded upon a Florida Supreme Court case regarding divorce and beneficiary designations, right? And in Florida, understand that when you get divorced, your preferences for a lot of probate stuff goes away. Right? If you're a spouse, there's a preference to be appointed personal representative of the estate, or at least greater consideration is given to you. And you have preferences for property rights and inheritance rights. If you get divorced and you're named as personal representative in a will, that's no longer valid, right? And now we have the same law with beneficiary designations, such as certain accounts and life insurance contracts, right? So divorce lawyers, family law lawyers, if your parties are getting divorced and there's a life insurance contract out there, you need to know who's going to be the owner, who can change the beneficiary, and who the beneficiary is going to be. And be mindful of a very unique set of facts. If you have a life insurance contract and you want the former spouse to continue to be the beneficiary, you need to set that forth with particularity and specificity in an order or some type of marital settlement agreement, and perhaps by some other evidence. Because this new law would suggest that if your former spouse is a beneficiary and you get divorced, bam, that former spouse is no longer a beneficiary. The Spoor v. Berryman case is a Supreme Court case in Florida that says parties to a prenuptial agreement are creditors when one of those parties passes away. Former spouses are creditors. A newer area of the law is spousal rights procured by fraud, duress, or undue influence. 732-805 in our probate code, it follows, it's the second statute after the Slayer statute, which is 732.802. You know, a killer is not entitled to receive property or other benefits if they've led to the demise of a deceased person, right? So be mindful of that, particularly in the divorce setting. But the 732-805, you can post-death challenge the validity of a marriage and challenge spousal rights under very special limited circumstances. Read 732-805 to learn more about that. Marital settlement agreements and final judgments. Remember, marital agreements are most probably going to try to limit beneficiary rights. Be mindful that the children, I know I mentioned this earlier, the children or other persons to a property distribution, order or judgment, or a marital settlement agreement may be beneficiaries or third-party beneficiaries, and they may have standing to enforce an agreement. So a marital settlement agreement says between two divorcing spouses, we're going to put some money aside for a minor child, and then one of the spouses dies, and maybe they didn't do that. And if there's a minor now who survives and they want to enforce their rights into that agreement, they need to do it through their parent and natural guardian or a guardian ad litem or a guardian. Or if that minor child is now an adult, they can do it themselves, but they need to do it or they're going to lose those rights. Some recurring problems that we see from divorce lawyers, probate clients, and whatnot is the life insurance. I can't tell you how many times we get calls because people say I was supposed to be the beneficiary or an owner of a life insurance policy, and I don't know where it is. So-and-so was supposed to keep a life insurance policy for my benefit, and they didn't. Or the beneficiary changed. There's ways to address that, and waiting till somebody dies is not always the best way to do that. And of course, if a spouse owes you money, you're probably going to hear, if you're a former spouse, that when they died, they didn't have any money. It's all gone. And so you need to know how to conduct financial discovery. You need to know how to look for that money and find out where it went. Very common scenario, recurring scenario. People are married. Remember, duration of marriage does not matter. They stop living together, but they never get divorced. That means when one of those spouses dies, the surviving spouse still is a surviving spouse and still has very, very valuable property rights, unless there was a prenup or some type of valid waiver of those inheritance rights. Recurring problems, rights of minor children. We see this all the time, particularly when they're third-party beneficiaries of marital settlement agreements and orders on property distribution. Adult children objecting to a parent's marriage post-death. That's the 732.805. Spousal rights procured by fraud, duress, or undue influence. which we discussed a little bit earlier, you can challenge after death of a parent a marriage of that parent to a spouse. You can bring allegations of undue influence, fraud, and duress if that marriage was procured improperly. Check out the Florida Probate Code to learn more about that. So in conclusion, we've seen today that there is a lot of overlap between family law and Florida probate law or Florida estate law. For the time that we've spent now, you'll receive 1 continuing legal education credit from the Florida Bar. The reference number for your self-reporting is on the screen, 170-4175N. If you'd like to attend other continuing legal education courses free of charge from Pankauski Hauser, please visit our website at phflorida.com. Click on the button that denotes videos and webinars, or you could call Amanda at 561-514-0900, extension 101, or you could email her at amanda@phflorida.com. My name is John Pankauski. If you have a probate or divorce proceeding that involves a decedent, estate, trust, life insurance contract, or homestead or inheritance rights, or third-party beneficiary rights, such as for those of a minor child, it would be a pleasure to speak with you and work with you on any number of cases. I want to thank you for listening. And if you're in downtown West Palm Beach, I invite you to stop by and meet us at 415 South Olive Avenue. We have a brand new building just blocks from the main courthouse, the probate court, and the federal court. My name is John Pankauski. This concludes this CLE on When Worlds Collide, the overlap between Florida probate and family law. Thank you for attending.